Many of us have encountered situations where we either make an empty promise or receive one, but what happens if these empty promises are taken to court, and the court orders that they must be fulfilled? For instance, imagine jokingly promising someone $11 million if you win the lottery and then actually winning, only for the court to rule that you must honor that promise. In today's case, such an empty promise resulted in a cost of $11 million. This is a story about Moore and Aubusson, a landmark case. You can find additional details of this legal case in the description below. Welcome back to my channel. I'm the Storytellawyer. I'm a lawyer and storyteller. The purpose of sharing fascinating real-life cases is to show that law is both fun and essential for everyone. Be sure to click like, share and subscribe for more legal stories and updates. The content in this video is meant for educational and entertainment purposes and not intended to provide legal advice of any kind. Storytellawyer will not be liable for actions taken based on the content provided in this video. Today, I will tell you a story of a fascinating Supreme Court case that shows how empty promises can override a written testamentary or will. A will is a legal document that specifies how an individual's assets and affairs are to be managed following their death. It provides clear instructions regarding the distribution of property and the handling of other personal matters. Let's get started. David and Dwayne, a couple, lived next door to Barbara. Barbara, who had no immediate family nearby, grew close to David and Dwayne. Barbara was very old and often expressed her desire to stay in her home and not move to a nursing home or a care facility. Barbara wished for a quiet and peaceful life at her house without any obstructions to her view while she was alive. She requested that David and Dwayne provide care for her and stop their home renovations while she was alive. In exchange for their care and for maintaining the unobstructed view of her property, Barbara verbally promised to leave her $11 million estate to them. Barbara owned two valuable neighboring properties, and her estate was valued at approximately $11 million at the time. When Barbara passed away, her will did not include the promise. Her will left the $11 million estate to other beneficiaries, Barbara's siblings. In Barbara's will, the officially documented primary beneficiaries were her siblings. There was nothing left for David and Dwayne. David and Dwayne were shocked and decided to take legal action. David and Dwayne claimed that Barbara had made a verbal promise. They argued that Barbara's promise should be honored, fulfilled, and enforced based on principles of proprietary and equitable estoppel. Estoppel is a legal doctrine designed to enforce fairness and prevent harm caused by inconsistent behavior or broken promises. Estoppel prevents someone from going back on a promise if another person has relied on it to their detriment. It applies in situations where it would be unfair to allow the person who made the promise to act contrary to it. Barbara made a promise, but her will did not include the promise. David and Dwayne argued that Barbara's promise should be enforced based on estoppel because they relied on her promise to their detriment, meaning David and Dwayne suffered a loss because of her promise. Barbara made a promise to David and Dwayne that she would leave her $11 million estate to them if they took care of her and did not obstruct her property's view with their renovations. David and Dwayne relied on this promise by providing care and support to Barbara and stopped renovating their house. David and Dwayne suffered detriment because they changed their plans and invested time and effort based on Barbara's promise. It would be unfair or unjust for Barbara to change her mind and go back on this promise. Proving Barbara's verbal promises posed significant challenges. With Barbara's passing, cross-examination of counter-arguments was not feasible. To substantiate their claim, David and Dwayne presented multiple pieces of evidence. The first evidence was witness testimonies. They provided their own testimonies and those of friends who had heard Barbara express her intentions of leaving them the estate. Second evidence was consistent behavior. They showed that their actions, such as providing care and not obstructing the view of Barbara's house, were consistent with Barbara's promise. Was there any other reason for David and Deween to care for Barbara or discontinue their house remodeling? No. Third evidence. They highlighted their close relationship with Barbara and their involvement in her personal and financial matters. David and Deween were significantly involved in Barbara's personal and financial matters. They provided care and support to Barbara, especially after the death of her husband. They helped her with daily tasks and ensured she could stay in her home, as she wished to avoid moving to a nursing home. David took on the role of managing the receipt of rents from the tenants of Barbara's rental properties. They were involved in discussions about Barbara's testamentary intentions and her financial affairs. They provided advice and assistance regarding her personal and financial decisions. Their close relationship with Barbara and their involvement in her personal and financial matters were key factors in their claim that Barbara had promised to leave her estate to them in return for their care and support. So what did the court find? The court found and ruled that the verbal promise of Barbara overrode the provisions outlined in her will. The court found that Barbara had indeed made a verbal promise to David and Deween. The judge declared that the $11 million estate should be distributed and transferred to David and Deween. This decision was based on the principles of ESTOPPEL, which prevents a person from going back on a promise if someone else has relied on it to their detriment. This case highlights the importance of verbal promises and how they can be legally enforceable under certain circumstances. While it's always best to have agreements in writing, verbal promises can also hold significant weight in the eyes of the law. Avoid making promises that you cannot keep. There is a saying that promises are meant to be broken, but be cautious, it could backfire. Let me ask you questions about verbal promises and written wills. Was the judgment fair, given that the dead cannot speak? Is it fair for the court to enforce a verbal promise over a written will, especially when it involves a significant estate like Barbara's, $11 million? Leave comments below. Thank you for watching. Don't forget to like, share and subscribe for more insightful stories on legal cases.